all the similar matters have been stayed by this court now, because the matter is pending before the apex court. I have furnished that order also, my lord.
May I submit? My lord, from the very beginning, there is no say in item number 1, my lord. That is, from the very, there is no say, my lord. But, my lord, today, during the course of the day, some technical difficulty not filed yesterday, my lord, but today, during the course of the day, we are going to file the objection, my lord. And in item number 30, my lord, we have filed one IA for verification petition. Item number 30, it is similar case, my lord, that is not my lord. So, my lord, kindly taken on Friday or Thursday, my lord. Only 1 day, only accommodate for only 1 day, but during the course of the day, we are going to file. Yesterday, everything is due to some signature of the my lord.
Pure.
Yes. No, my lord, today, I'm, that is the, yes,
They will fight.
yes, my lord, today, during the course of the day, my lord.
What the not depend on to that of you
Yes.
or whom they
So, but only accommodate for today, my lord, and they,
more people that
yes, my lord, next for the lower court is on 5th of August, my lord. So, my lord, kindly they cannot day after tomorrow, Thursday, my
My
lord.
lord, I don't know why all these matters have been stayed by the same.
Because, my lord, that
Order
case
cannot
come
be
after,
extended
my lord.
in this case, my lord.
Because, my
On the
lord,
same
at the
ground.
point of other cases, there is a no now there is a case of Motonlal case. On the basis of that, we are ready to argue the matter, my lord. That is coming
In that case, my lord,
2022,
all
my lord.
the other cases which has been stated have to be.
Yes, my lord, that's why we have filed
or
the certificate.
that what
But-
other
Yes, my lord. Yes, sir. Kindly, my lord, yes, yes,
that ultimately on a perfect of
my lord, regarding that Supreme Court order, that's why we have filed one IA in item number 13, my lord.
and what happened.
Because, my lord, kindly, but yesterday, sorry, tomorrow.
Why were there was an order passed by right? But prior we hit the matter for our that was for not after most record look this is the path the entire matter for right after path of our for thereafter the move was a big what happened the matter when the effect of the consequence segment of online or here because that's what I could not have direct but all these ideas was that showing that the consequence judgment that because that matter is here and there are it would be topic that will be on technique and length of what happened for the 9 years, taking the time that just of him. That's why I'm asking you. Since the matter is subject for
Yes,
the
yes.
traffic, what will happen?
Also, what is the objective of the Supreme Court matter?
Even if you vacate this case and you proceed, will not be such like same status. In fact, in one of the judges, one of the judgments, uh, it put it as that, right? Because so if just being a court officer, you have to be, then fiction to Thursday, no, to think over the Thursday. But how to overcome that? Tomorrow, what will happen? The ultimate critical time, that's what happens. So, but no, but just I what will happen? Let us say how on Thursday.
Thursday, my lord, tomorrow, next Thursday.
First of all,
Has must have
yes, Mr. Hart. Right. It is not. Item number 40. One folder. CBI is participated. So, with regard to other cases, there is no relation. Maybe separate. It has no connection. No connection with what? What? With epileptic, the command. 13 I am appearing. So it's better that 15. Right. It is not connected to this. Take an instruction from my senior. Pick in flexibility also. That's it. I want from tomorrow or 20 time. No way connect. No way that. Prayer that in this section item number 14 is for quashing of the order passed by that. These are विषय चालू कर Lord, highly. Lordship, item 13, I submit. It will be on first. Yes, Lordship, if Lordship wants to take it up, there is an IA in which we have to file objection. If Lordship decides to take it up on Thursday, then we Lordship may grant us to file objection. That application, Lordship, when did I was, Ms. Kayan, when did you file the IA? 5, 6, 5, 6, 20. You were 38th of July. Wherever it's there, already passed an order. The solicitor has passed an order, whatever is the order, it's done. Yes, sir.
Here in this case, this revision is filed challenging the order whereby Lordship 311 petition for recalling the IO was allowed. Here in this case, your Lordship will find that the initially in the charge sheet, page 17, there were 5 numbers of witnesses were mentioned.
Yes,
There,
yes, Let's look up here. You got the record because earlier.
I have not. I'll go through within the day.
Sir, last.
Fair Give me a fair question. Yeah.
Have not 30.
13.
It's not that.
Interim order may become. Interim order is outlined. May please your lord.
Sir,
The matter may be passed over for the time near action and
since 21st of June 2024, interim order is not.
Matter has been listed after
They are all listed on 2 occasions. Because on 15/12/2023, there was an order for 21st, not accepted.
on that day.
Not accepted now. Yes, next.
so kindly the matter may be passed over for the time that my senior left in another.
Petition has been filed under the section 12 of the TV Act, my lord, by the daughter against the mother and the two brothers. And the two brothers which are not residing with the daughter, lord. And the mother has already filed a case under section 12 of the TV Act, lord, in the long back in the year 2021, lord. That case is still pending. And subsequently, this case has been lost. In the case filed by the mother, lordship, there is an interim order also, ex parte interim order. Correction order was passed on 3/2/2021, whereby it was directed that not to dispossess the aggrieved person from the shared household. And thereafter, I have been able to secure a place in the shared household. And since then, I have been living there, the mother. And one of the brother is residing at Delhi, lordship, and another brother is residing at Bijpur. They are not residing in the shared house. But they have also been arraigned as an respondent in
See, it's a family matter. Completely family. Should not have happened in a family. Why don't you go for mediation?
Lordship, the mediation has already been failed, Lord. In the original case, that is DB case number 7 of the 2021,
Right?
parties were sent for mediation.
See, basically, these matters can be solved. Only ego has to be removed.
Lordship, let me
Right.
tell
It appears all are well to do. The matter of a house on a common land constructed by husband of that was occupying government land without any basis.
Lord.
Where is the stand? These matters are put and when clearly decided in a mediation,
even the brothers, Lordship,
we understood.
they have tried to pacify the situation, Lordship, but they have also failed.
Basically, will not take anyone that is purely a dispute, will dispute relating to occupation, legally or illegally constructed by the late father. Purely government,
Government land, Lordship. Let me-
right? And you should decide. This should come to court at all.
Lordship, why the matter has been
Mother filing in DV case against daughter. Daughter is filing DV case against mother. This matter that's very court.
Lordship, why we are approaching this honorable court, Lordship? Because the sons, both the sons are residing in a different place.
No, we understand. But it is
Now only to
that
drag
can
them,
be taken care of. But thing is this, I think this issue can be resolved.
Lordship,
Considering the fact that the land, the government land,
Lordship,
and then till date there is no application before the government for giving that land, settle that land with the pensioner or with the daughter or anyone else. Right? So there is the right over that property. Where is that right for the property where you are fighting? None of you has that right.
admittedly, Lord. There is the action of Patta. Government land.
And it is rarely basis. When you have no right over the land, the house that you have constructed is also meaningless. Any point of time, government can put it out.
Take over.
And you're fighting for. And apparently from the letter, from the petition itself, by the respondent, doctor, clearly said it's to decide by the kind of house of our father. Think over. This is a matter where court should not use this research during the time. Talk to
Take
your,
notice,
talk
we
to
have-
your party, will send the matter for me. We have to make it. The reason is you don't have a right to hold the land. The government.
That is the admitted question.
So
Lord. That is not
where is
contested.
your right? Neither the petitioner nor the respondents. So Kalita, you are appearing.
Lordship,
See, this matter will not spend our time.
Lordship,
You go to mediator.
Yes.
See, basically, Mr. Kalita, we have read it.
basically,
The
Lordship,
father constructed a house.
Yes.
Occupying government land
Yes.
without any right. The land was neither settled for 1 year, nothing.
Lordship,
It's an illegal occupation over the government land. Now, you are claiming and the petitioners are claiming over
that
house.
issue is Lordship is already
Right.
adjudicating Lordship in trial court, that is different.
Whatever.
Yes.
Now, thing is this, where you are right, put the partition.
No, regarding this case pertains to Lordship, the domestic violence issue.
True. Domestic violation because of the issue is what? Only the
Issue is, yes, regarding land.
house over illegal construction of a house by the father of these parties, right? And that also over a government land, where you have no right at all.
And in this case also, Lordship, only Lordship, the domestic incident report
Go
was
to
called.
the, we'll send it for mediation. Decide, these are the egos you have
Yeah.
and where you have no right. Neither you have the rights, nor the petty respondents have the right.
Sure.
Think over and tell us by Monday.
So in this,
These matters are not to be decided by the court. You go.
Lordship, definitely Lordship will go decide the trial court either or Lordship amicably that may be settled between the parties. But thing is that only Lordship, the notice was issued to the,
Mr. Kalita,
Yes.
we have personally seen
Yes.
the Lok Adalats. One of the lawyer was not aware, I was sitting there,
Lord.
was telling the concerned judge was presiding in the Lok Adalat that only at my cost,
Please proceed.
only at my cost,
Yes.
the parties have
Come
agreed
with-
because the lawyer will not get the fees once the matter is decided, compromise in Lok Adalat.
Yes,
And he was telling, I was sitting there, he was not aware that I was sitting.
Lord.
That's happened in Guwahati.
Yes.
Sometimes everybody should overcome the egos in the lawyers. So this matter should be decided by
Lordship,
the,
in this case, we have already put an effort, Lordship. Already the case was sent to the mediation, Lordship.
that was in the
subsequently-
court below, right?
Lordship,
That is what the High Court by
Lordship, Lordship.
Lord, if you send back the matter to the trial court will decide whether
will not send it to the trial court. Do it in the High Court mediation.
that can be done. Lord.
But if the happy parties, your parties should agree first. Make to inform them they have no rights over the land. If we write one single line here, it is sufficient. Neither you have a right nor he has.
Lord,
Where has
please-
the right government land? It is an
Uh,
illegal occupation, maybe for
occupation-
30 years, 40 years. What is the judgment by the apex court?
Lord,
So even our High Court has passed that order.
that's true, Lord.
Fighting for the land and the house where you have no right.
Only the
Think
Lord
over.
possession. Only the possession of the Lord.
Even in
document.
possession, that's illegal possession. Nothing. Think over.
Lord, you can send me your,
Up
yes,
to you. You should pressurize upon your parties to have mediation. They decide the matter.
I
Nothing
can
else.
convince my client Lord, to come to mediation.
Lordship.
We'll pass the order.
Lord.
We'll talk
There is
to
an interim
mediation.
order, Lordship. That may kindly be continued till next year.
We'll fix a date.
Lord.
Okay, let's be on 7, but in the morning itself, make a mention. Pass the order on 7.
On 7. Lord. Obliged.
Obliged.
Yes. The parties better for some time on that day.
Yes, Lord.
Your only ground is that it has been issued from the same proprietarial part that the respondent is also party.
Lordship, there is one more discrepancy, Lordship, that I'd like to mention. Lordship, in the evidence on affidavit, the complainant, Lordship, he has stated that the check was issued to him by the accused, but filling up the details. Whereas in his cross-examination, he has stated that he has filled up the details himself.
It is there, we have seen that day.
Yes, Lordship. And Lordship, also the point where in the notice, that reflects the advocate notice, the accused had raised the ground that the complainant did not have the financial capacity. That was also overlooked by the learned trial court and the appellate court.
Will you take that ground for the trial court?
Yes, Lord.
Before the trial court?
Trial court, the written argument was not there, Lordship. In the court, it was there. Lord. And Lordship, the accused also used his tax return. The trial court failed to, take into consideration the point that Lordship, the presumption stated as in 118 and 159 is rebuttable, and Lordship, the accused only needs to raise probable defense. Lord. He has already raised probable defense by his cross-examination, by the means of its like the advocate notice. Lord. These grounds have not been taken into account by trial court. Lord. Then the check was issued from the account of the official partnership account. And Lordship, one more interesting thing. In the partnership, Lordship, there is an arbitration clause. What's page
Just
46?
a minute. What is the bank account number? From where this check was operated?
Bank account number 02642 and 507984.
Bank,
Bank HDFC Bangapur.
when it was issued? As per the
But affidavit issue date was 8/4/2016 for rupees 15. That's quite a complaint. Evidence and
8/4.
yeah.
Whether this agreement was executed?
Lordship. Lordship. Yes, Lord. So
As what?
exhibit 1, I think. Copy of the agreement is exhibited as exhibit 1.
Take your seat. Yes, let's submit. That's it, the evidence.
If I may read from the judgment of KBC, paragraph 3, Lord. Page, page 3, paragraph 3. I am the screen summarizing of the Basalingappa version piece of the judgment. This court inter alia has held as follows. We have noticed the ratio laid down in this court in the above cases on section 118A and
NRC
139.
of the judgment.
Yes, sir. We have, once the execution of check is admitted, section 139 of the Act mandates the presumption that the check was for discharge of any debt or liability. Presumption under section 139 is a rebuttable presumption, and the onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of
Which page you are reading?
is 3, Lord.
Page 3.
Paragraph 3, Lord.
Calcutta. This is the judgment you are reading,
Yes,
right?
sir. The complainant assessment, yes. CPO relation to the judgment.
Yes.
The presumption under section 139 is a rebuttable presumption, and the onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of preponderance of possibilities. To rebut the presumption, it is often for the accused to rely on evidence led by him, or the accused can also rely on the material submitted by the complainant in order to raise a probable defense. Inference of preponderance of possibilities can be drawn not only from the materials brought on record by the parties, but also by reference to the circumstances upon which they rely. And lastly, Lordship, it is not necessary for the accused to come in the witness box to support his defense. Lordship, in this respect, I beg to submit, Lordship. The burden of proving the non-existence of legally enforceable debt is not that heavy on the accused, Lordship. He has to raise a probable defense. In this case, Lordship, the probable defense has already been raised, Lord.
You're not getting it very well.
Can I?
Just which annexure you are reading?
I'm reading from the judgment of Tehri Singh, Lord.
You have a copy.
Yes, Lord.
You have a copy. You're relying on this judgment.
Eighth paragraph.
Yes.
Summarization of the judgment of Vasalingappa. The blank. We have noticed the ratio laid down by this court in the above cases on sections 118A and 113. We now summarize the principles enumerated by this court in the following manner. Once the execution of check is admitted, section 139 of the Act mandates the presumption that the check was for the discharge of any debt or liability. Then, Lordship, the presumption under section 139 is a rebuttable presumption, and the onus is on the accused to raise a probable defense. The standard of proof for rebutting the presumption is that of preponderance of probability. To rebut the presumption, it is often for the accused to rely on the evidence laid by him, or the accused can also rely on the material submitted by the complainant in order to raise a probable defense. Inference of preponderance of probabilities can be drawn not only from the materials brought on record by the parties, but also by reference to the circumstances upon which they rely. It is not necessary for the accused to come into the witness box to support his defense. These are the principles laid down in this judgment, Lord. It shows, Lordship, that the burden on the accused is not as heavy as the complainant, Lord. What he has to do is raise a probable defense. Lord. He does not have to prove. He does not have to prove his. Beyond reasonable doubt. Beyond reasonable doubt.
Yes.
Then, Lordship, paragraph 9, Lordship, of the same judgment. Paragraph 9, Lordship. Right.
page 5. The trial court and the first appellate court have noted that in case under section 138 of NI Act, the complainant need not show in his first instance that he had the capacity. The proceedings under section 138 of NI Act is not a civil suit. At the time when the complainant gives his evidence, unless the case is set up in reply notice to the statutory notice sent that the complainant did not have the wherewithal, it cannot be expected of the complainant to initially lead evidence to show that he had the financial capacity. To that extent, the courts, in our view, were right in holding on to those lines. However, the accused has the right to demonstrate that the complainant in a particular case did not have the capacity, and therefore the case of the accused is acceptable, which he can do by producing independent materials, namely by examining his witnesses and producing documents. It is also open to him to establish the very same aspect by pointing to the materials produced by the complainant himself. He can furthermore importantly achieve this result through the cross-examination of witnesses of the complainant. Importantly, achieve this result of the complainant. Ultimately, it becomes the duty of the court to consider carefully and appreciate the totality of the evidence and then come to a conclusion whether in the given case the accused has shown that the case of the complainant is in peril for the reason that the accused has established a probable defense. Now, Lordship, going by this paragraph, we have already set up that the complainant did not have the financial capacity to give a loan of rupees 15 lakh by the reply to the statutory notice. This fact has not been dealt with either by the trial court or by the appellate court. Then, Lordship, in his exhibit, he had exhibited the partnership deed. And the account from which the interim check, from which account it has been issued, that is the official account of the partnership. So, if the official account of the official check of the Partnership Act has been dishonored, then it binds both the partners. In this case, the complainant is also partner of the partnership fund. Then, Lordship, please have a look at page 43, Lordship. The petition, Lord. Page 46. Clause 20, Lordship, page 46. Any dispute or difference which may arise between the partners or the representatives. Yes. So, Lordship, there is also an arbitration clause. In case of arbitration clause, it becomes preemptory for the court to refer to arbitration, but nothing was done. And he did not even approach the arbitration tribunal or anything like that. Then, Lordship, in his evidence on affidavit, he stated that I have also already submitted, Lordship. He has stated that the accused issued him the check by filling up the details. While in his cross-examination, he has stated that he has filled up the details. There is a severe contradiction, Lord.
Page.
Okay, page 72. 7 number 5. Yes. 7 number 5.
Evidence in affidavit.
Yes, Lord. That with passage of time, the accused started avoiding the deponent and also did not react positively to the request of the deponent to his share in the profit. In view of the growing difference between the parties, the deponent decided to terminate the partnership. But all his requests to do the needful for such termination completely ignored by the accused. However, after a lot of persuasion, the accused issued a check bearing number Iman dated 8/4/2016 for rupees 15 lakhs only, being the amount paid to the accused by the deponent towards the capital of the firm drawn on HDFC Bank, Bhangaghar, branch, GS Road, Guwahati 5, in favor of the deponent. The said check was issued by the accused in discharge of his existing and legally enforceable debt. Then, Lordship, come to page page 97. Cross-examination of PW.
onward, I have been, the third line, Lordship, I have written myself, my name and amount in exhibit two. The accused gave his reply to his advocate to my advocate. Lordship, this fact was not mentioned by the complainant in his, either in his complaint petition or evidence in affidavit.
Shown on page 97.
Third line, I have written myself, my name and amount in exhibit two.
Yes, this is a contradiction.
That's what. Then Lord, Lordship, please come to page 96, Lordship. Now, in his, evidence on affidavit and complaint petition, he has stated that he has sold his land, Lordship. And also he had taken loan from some people at on interest at a rate of 10 to 15%. But however, in his evidence, in his cross examination, Lordship, the complainant has denied.
How it relates to the check? How it relates to the issuance of the check? But how that part of the submission or the evidence relates to the check?
Lordship, it shows that the complainant, he had, lied about his financial capacity, Lordship. That he had no transaction took place, Lordship. This is regarding the non-existence of legal and equitable debt, Lordship. He could not prove any transaction whatsoever, Lordship.
Yes. That issue I think so is like now 11. But because it is that you have issued a check that has bounced and now the corporation has that. Yes. Yes, you have shown the contradiction that was not considered by both.
Yes.
Then
Lordship, then, Lordship, that those contradictions, Lordship, it clearly shows that the complainant neither did he have the financial capacity to issue, to give a loan of rupees 15 lakhs, nor was he actually a holder in due course of the check. There was a partnership agreement, and he had written a letter to the bank, Lordship, that his check has been placed or misused. And Lordship, also in the statutory notice, reply to the petitioner, he also stated that the complainant did not have the financial capacity. And in fact, that the accused that helped the complainant in setting up a business. But Lordship, all of these facts, these were overlooked by the trial court as well as the appellate court. So mere Lordship, the act of the accused, the complainant, contradicting the fact regarding the filling up of the check, that is a severe discrepancy in this case. Lordship. Once he has said that the accused had himself filled up the check, then he has stated in his prosecution that it was he himself, the complainant who has filled up the check. That means it was clearly shows that the check was given to him for some other purpose, and it was misused by the complainant. This fact was overlooked by the trial court as well as the appellate court. If I also have some judgments, if I'd like to present.
last picture.
Lordship,
One you have already given.
Lordship,
Right.
one yes, but hearing I have already given. Lordship,
anything-
Asa Linkappa and Mutitappa, I think Lordship has that.
One.
Asa Linkappa. Lordship Mutitappa. So given a copy, Lordship, I have got.
Giving up that date?
No, Lordship, I am giving. Lordship, in this case, Lordship,
Hmm.
the apex court has held that the preponderance of probability is not such that it has to be put behind reasonable doubt. Nor has it,
Do you have a copy or not?
no, Lordship.
No, no, that's- Yes, which para?
Lordship, I'd like to refer to a judgment of the Honorable Court, Lordship, Hogan Uza.
What you have said about it, actually. Lingappa, which paragraph?
Lordship, paragraph 23, Lordship. It is the same, Lordship, the summarization of the principles as laid down by the apex court.
Paragraph 23.
Lord.
Anything from that particular?
Lordship, these are the principles. The main case is summarized through these principles. Lordship, that I would like to. Lordship, case of this Honorable Court, Lordship, Hogan Uza versus Lalitya Kumar Das. Lordship, paragraph 6, Lordship. Page 6, paragraph 11. Lordship. The burden of proof of the accused to disprove the presumption under section 138 and 118 of NI Act are not heavy. The preponderance of probability through direct or substantial evidence is sufficient enough to shift the onus to the complainant. The apex court in Messrs. Narayana Menon at the rate of Money versus State of Kerala held that the standard of proof evidently is preponderance of probability. Inference of preponderance of probability can be drawn not only from the materials on records but also by reference to the circumstances upon which it relies. Which paragraph? That's paragraph 11, page number 6. Then, Lordship, the burden of proof of the accused to disprove the presumption under section 138 and 118 of NI Act are not heavy. Preponderance of probability through direct or substantial evidence is sufficient enough to shift the onus to the complainant. The apex court in Messrs. Narayana Menon versus State of Kerala held that the standard of proof evidently is preponderance of probabilities. Inference of preponderance of probabilities can be drawn not only from the materials on record, but also by reference to the circumstances upon which it relies. Then look at the next paragraph. Applying the state definitions of proof or disprove the principle behind section 118A of the Act, the court shall presume a negotiable instrument to be for consideration unless and until considering the matter before it. It either believes the consideration does not exist or considers the non-existence of consideration so probable that a prudent man ought, under circumstances of the particular case, to act upon the supposition that the consideration does not exist. For rebutting such presumption, what is needed is to raise a probable defense. Even for the said purpose, the evidence adduced on behalf of the complainant could be relied. Okay. Then Lordship, paragraph 24. A division bench of this court in Bharat Barrel and Drum Manufacturing Company versus Amin 10 PRLR, albeit in a civil case, laid down the law in the following terms. Upon consideration of various judgments as noted herein above, the position of law which emerges is that once execution of promissory note is admitted, the presumption under section 118A would arise that it is supported by consideration. Such a presumption is rebuttable. The defendant can prove the non-existence of consideration by raising a probable defense. If the defendant is proved to have discharged the initial onus of showing the existence of consideration was improbable or doubtful, the same was illegal, the onus would shift to the plaintiff, who will be obliged to prove it as a matter of fact, and upon its failure to prove, would entitle him to the grant of relief on the basis of negotiable instrument. The burden upon the defendant of proving the non-existence of consideration can be either direct or by bringing on record a preponderance of possibilities by reference to circumstances upon which he relies. In such an event, the plaintiff is entitled under law to rely upon all evidences laid in the case, including of the plaintiffs as well. In case where the defendant fails to discharge the initial onus of proof by showing non-existence of consideration, the plaintiff would invariably be entitled to the benefits of presumption arising under section 118A in his favor. The court may not insist upon the defendant to dispute the existence of consideration by leading direct evidence, as the existence of negative evidence is neither possible nor contemplated, and even if led, it is to be seen without doubt. Then Lordship, paragraph 25. The court therefore clearly appointed that it is not necessary for the defendant to disprove the existence of consideration by way of direct evidence. The standard of proof evidently is preponderance of probability. Inference of preponderance of probability can be drawn not only from the materials on record, but also by reference to the circumstances upon which it is. Lordship, the circumstances in this case, Lord, it clearly shows, the Lordship, that the check was not issued in discharge of a legal and enforceable debt, Lord. In his cross-examination, Lordship, the complainant has contradicted his own evidence on affidavit and complaint petition, Lord.
Only ground is there.
But, those are some of the major grounds, Lord. And the discrepancies are also major, Lord. Especially regarding the filling of the details of the check in question, Lord. Because, Lord, the contradictions are both on record. One on the evidence on affidavit and another on the cross-examination of the complainant, Lord. Trial court and the appellate court, Lordship, they have taken a very mechanical view in this respect, Lord. They have just stated that since the check was issued and it was signed, so the question of legal and enforceable debt was already present and the financial capacity was also there. They totally ignored the reply, Lordship. Also the contradictions of the evidence on affidavit and the cross-examination. Check, actually, that is with the original record.
Page number 88.
No, it's part of the record. 88, man.
88, right?
88.
Yeah.
Page 8.
Mr. Das, anything else?
Yeah, submit.
Yes, Mr. Na.
Before I
So that
start,
has totally contradicted, right?
according to their contradiction, I will show there is absolutely no contradiction. I will start with a caution mark. Because my lord is exercising discretionary jurisdiction under revisional court. So the my lord will not tamper with a concurrent finding unless, my lord, there is apparent error of law or conclusion is ex specie, my lord, perverse.
Yes.
Unless it is perverse. Now let us do it one by one. My. Regarding financial capacity. First is I failed to prove my financial capacity. Lordship may kindly appreciate it. It's a signed blank check. Once its signature is admitted, therefore there is this, my lord, this 139 presumption will spring to life. And it operates till the time the accused able to charge the initial burden by some cogent evidence. Based on, my lord, not on strict proof, absolutely, it's the law, there is no dispute on that. Preponderance of probability, but not preponderance of possibility. Preponderance of probability means there must be some cogent evidence. Now, at what stage, my lord, a complainant is liable to prove his income? Only when he is able to discharge the initial burden, not before that. That's a clear proposition of law. Now, what is his primary defense? His primary defense, in his reply to our statutory notice, is that this check was issued for paying provident fund. That is his defense. That's the defense setup. In the cross-examination, his stand is the check was issued for paying electricity bill. So his primary defense falls apart, falls to the ground. And therefore rightly disbelieved. Therefore, since he failed to discharge the initial burden, I'm not supposed to prove anything about my income and this non-examination of witnesses from whom I borrowed this amount. There is no need for that. And that is clearly reflected both in the trial court order and the appellate court order. Clearly discussed that. Why it was disbelieved? Can you see trial court order?
Yeah, please on that.
Yes, my lord. So there is no
This is the
need.
only ground which we trial that present is like here.
Yes.
Oh.
This is paying for electricity. But it is primary defense. There is contradiction. Secondly, my lord, it said about the blank check. Law is very subtle. Under the scheme of NI Act, there is no need that the drawer of a check should also fill up all the fields, blanks of the check. There is no need for that. Can we see section 20 of the NI Act?
Yes.
section 20. Inchoate stamp instrument. When one person signs and delivers to another a paper stamped in accordance with law relating to negotiable instruments, then in force in India, and either wholly blank or having written thereon an incomplete negotiable instrument, he thereby gives prima facie authority to the holder thereof to make or complete, as the case may be, upon it a negotiable instrument for any amount specified therein, and not exceeding the amount covered by the stamp. The person so signing shall be liable upon such instrument in the capacity in which he signed the same to any holder in due course for such amount. So if an incomplete negotiable instrument is tendered, that means it gives an authority to the holder to fill up the. Now, negotiable instrument is defined under section 13. That includes a check. Now, appellate court dealt with it, my lord. Para 31 and 32, Lord, you may kindly see page 176. Para 30. May I read? Here in this case, I'm reading from para 30, man. Here in this case, it is admitted by the appellant that he had issued Exhibit 2 check and the signature appearing therein is of him. It is not disputed the check in question on being presented to the banker of the complainant, same had been dishonored and the check had been returned with the check return memo on the ground of insufficient fund. On the presumption under section 180, 118 and 139 comes into play in favor of the respondent. Here the reverse burden lies on the appellant to rebut that, and he had not such liability to preponderance of probability. Now 31. It is available evidence that the name and amount of the check has been inserted by the complainant in Exhibit 2 in one hand. On the other hand, there is assertion that the complainant paid an amount of 15 lakhs towards the capital of the partnership firm, being his contribution for doing business. And they have worked together for 50 lakhs. Although PW1 had been thoroughly cross-examined by the appellant, but the said facts remain intact. On the contrary, there is evidence from DW1 that the complainant used to look after the affairs of the payment of salary, etc., to the employees of the firm, which inherently suggests that the complainant has been discharging his duty as an active partner of the firm. And there was work together which necessitates employment of as many as 10 employees. In support of filling up other details in the check by any other person, so-and-so of the appellant relied upon the decision of Bir Singh versus Mukesh Kumar reported in 2019 for SCC 197. Now, para 33 and 34 has been quoted. 33 is a meaningful reading of the provision of the Negotiable Instrument Act, including in particular section 20, 87 and 139, makes it amply clear that the person who signs a check and makes it over to the payee remains liable unless he adduces evidence to rebut the presumption, and that the check had been issued for payment of a debt or in discharge of a liability. It is immaterial that the check may have been filled in by any person other than the drawer, if the check is duly signed by the drawer. If the check is otherwise valid, the penal provision of section 138 would be effective. 34. If a signed blank check is voluntarily presented to a payee towards some payment, the payment may fill up the amount or other particulars. This is itself would not invalidate the check. the onus would still be on the accused to prove that the check was not in discharge of debt or liability by adducing evidence. Even a blank check leaf voluntarily signed and handed over by the accused who is towards some payment would attract presumption under Section 139 of the Negotiable Instrument Act in the absence of any cogent evidence to show that a check was not issued in discharge of a debt.
So you want to say that even if it is a blank check and it does not
Absolutely.
prove,
My lord,
then
my lord, this
there is no-
piercing subsequently, my lord, approved, this is by a division bench judgment, subsequently approved by a full bench in Kalamani tax. I will just refer here. 2021 5 SCC 283.
how the-
5 SCC 283.
it doesn't matter.
3 full bench, my lord. Para 17, where this Veer Singh was quoted with approval. And if it's para 17, it says even if we take the argument raised by the appellant at face value, the only a blank check and signed blank stamp papers were given to the respondent, yet the statutory presumption cannot be obliterated. It is useful to cite Veer Singh so and so, para 36 was the reference. Now one more judgment, my lord. Twenty-two 3 crimes, Supreme Court 345. 22 3 volume 3 crimes within bracket SC Supreme Court 345. That's the page number.
You have the part.
Yes. Oriental Bank of Commerce. Oriental Bank of Commerce versus Provod Kumar Tiwari. I'm relying on 11, 12, 13, 14, sorry, 11, 12, 13, and 14. 11, 12, 11 to 15. Here again, Veer Singh has been quoted with approval. para 11.
Whether the bidding again was created.
My lord. Para 14, Veer Singh,
Composition of the bidding was made.
my lord. Para 33 and 34 of the Veer Singh quoted. 15 says a drawer who signs a check and hands it over to the payee is presumed to be liable unless towards payment of a debt or in discharge of a liability. The presumption 139. That is para
Oriental
15.
Bank of Commerce.
My lord. Oriental Bank of Commerce versus Pramod Kumar Tiwari.
Uh,
11 to my lord 15.
That well, even liable to the details of the check with the account.
Exactly. That is settled. Unless that was rebutted. And his only rebuttal evidence is that it was issued for Provident Fund. Then he contradicts himself, saying that it issued for electricity. Well, now, by referring to page 72, which is our affidavit, page 72, when Leonard Prin is trying to submit that there is a contradiction. This is our evidence, affidavit on evidence. Para 5, we referred para 5, where he said he issued the check. We simply said the check was issued. Where is the contradiction? Under the NI Act, issue means a person who signs the check. That is it. So there is no contradiction. Then he also raised his arbitration clause. Now, where is the dispute to raise an arbitration clause? He voluntarily issued a check. Check was dishonored. Let it track the penal provision on the NI Act. There is no dispute. It's a criminal culpability. Then partnership account. Kindly see, this check was not issued in favor of a partnership firm. The check was issued, the account from where this check was issued was standing in the name of the proprietorship firm, of which the accused is the sole proprietor. Admitted fact. Because our agreement says, for the time being, we'll continue with that account, which the accused was maintaining at that time in the name of his proprietorship concern. That is our agreement. And subsequently, that will be transferred to the name of the partnership firm. Our case is that he declined to do that. Kindly see the check. It was not issued in the name of the partnership firm. And the checklist, pardon?
It belongs to whom?
The accused.
Now, you are relying on this agreement.
Yes.
Keep it on. From the agreement will act.
Well,
It's number 8.
Yes,
The right hand side down below it is what term?
fundamental,
Down below
authorized signatory,
authorized signatory.
author,
And we did.
Huh.
Right. Right. And that is the signature of the petitioner has proved it.
he admitted that.
Now the agreement, exhibit 1.
Yes.
Page number 41.
Yes. Yes.
Come to page number 44.
Yes.
The agreement you have admitted. Read clause 10 of the agreement.
Yes. I will explain that. I will explain that.
Kindly read.
Before that,
Kindly read.
all checks and other documents for the purpose of the firm shall be signed by both the parties. Yes. Kindly read para 2 and then para 9. Then we'll read 9. We'll read 10. The name of the firm shall at present so and so, and the name may be changed thereafter to some other name as desired by the partners. Be it stated herein that said Satyam Enterprise was initially a proprietorship firm standing in the name of one of the partners, namely so and so, that's the accused, and the partners have mutually agreed to retain the same name, the firm. However, henceforth so and so shall be a partnership firm rather than a proprietorship firm.
So henceforth means effect from 1st of April 2000.
Here, can you see para 9 then? About the bank. The partners have, for sake of convenience for the time being, mutually decided to carry on operating an already existing bank account with the so-and-so being account number standing in the name of the proprietorship firm. However, it has been mutually decided by the parties that immediately on execution, the partners shall approach the concerned bank to do the needful for transferring the account to the name of the partnership firm, and all money check so-and-so firm shall be paid in deposit with the said bank. So,
Then
content 10, it says that after it has been transferred, otherwise, my lord, it's admittedly it's a proprietorship firm.
was
Kindly,
from 1st April it is a partnership.
my lord, kindly say this account,
Account was the name of
a proprietorship
from-
concern.
was
No, kindly see, my lord. For changing, we have to approach the bank because it was there earlier. Earlier, my lord, he has a
new complete petition where you have that was single-handedly operating that partner
well, we have stated that,
in your complaint.
yes, I will say it evidence, and I'll come to this evidence.
See, page
Para
18,
71,
kindly
my lord,
read
kindly-
page 18. That is the reason we are asking you.
Yes.
Paragraph 10 of this agreement.
Yes.
And the check. Why the bank will show it is authorized signatory as far as the English, you know, signatory and signatory is different, you know. You know,
Yes, yes.
so if it is signatory, there's the requirement of 1 plus. Don't know how. But if it is authorized signatory means, you know,
Kindly see,
one. Reading this particular check,
in his,
reading this particular check, as per clause 10, has to be signed by both the parties. Because it is the agreement from 1st of April 2013. Partners. And as per that agreement, all checks have to be signed by both the partners.
my lord, kindly come to my evidence, page 70. Page 71. Para 4. As per the terms of the partnership agreement, all the check issued to the partnership firm against the state work deposited with the so-and-so standing in name of the proprietorship firm of the accused of which is the sole proprietor. It is pertinent to mention that the subsequent accused avoided all attempts of the deponent to do the needful to transferring the account to the name of the partnership firm in one pretext or the other. Now, kindly also see his evidence. Nowhere is stated that. He admitted it
Not
is in his
required as
name.
per the judgment of the apex. You can rely upon the documents placed by you.
Yes. Like, kindly see
Yes,
his
sir.
evidence. Our evidence, my lord, that this account,
Where is the proof that you have deposited in your cross? You have clearly said that there is proof. You have failed to show that you have sold that land. You have failed to place any other name from whom you have borrowed the amount. You have failed to show where you have deposited 6 lakhs of money or
Yes.
50,000, 50 lakhs of money to the that's not been proved.
well, the proof will come only when he is able to discharge the initial burden. Kindly see, my lord.
Detail, but that is the description of first of all, the account shows it is a partnership. Clearly, you are relying on the agreement. The agreement which you are relying clearly shows it has to be signed 40%. And that is why the checkbook clearly says authorized signatory. It is not a word that authorized signatory. Had it been the partnership firm, only to be a proprietorship firm account, then the name of the concerned signatory would have been typed out in check.
Well,
Right, Mr. Nath? And this is not new. This is 2013.
yes, 2013.
To ask any bank since when the name of the authorized signatory is printed out in the checkbook because it was the direction of the RBI.
His name would,
And
could
since
have been,
then- and since then, the names of the authorized signatories are printed out.
yes, it was not
Right.
printed.
It was not printed.
It was not
authorized.
printed.
That is why it is authorized signatories. Otherwise, it will have been proprietorship firm account.
Hmm.
Only the authorized.
Yes, yes,
This is your document.
yes, yes. No, my document says, my lord, that when we started, we
Now,
decided
just
to
tell
carry
us
with
one
it
more-
that
just
name.
tell us one more. Where from the appellate court came to the conclusion that this paragraph come to page 30, 17.
Yes,
Where from the appellate court came to the conclusion that you have deposited 15 lakh when in your own evidence it is clear that you have not placed anything for the trial court to prove that you have deposited that amount.
because there is a check in my favor.
Check is in favor. Check is in favor, that's right. There is no denial of the fact of the check is also on the side of the present.
Yes,
But where is the trial court? From what is the basis from where the trial court came to the conclusion that you have invested 15 lakhs of rupees in that partnership firm when in your evidence you clearly say that you have not placed anything before the trial? Mere submission is enough.
mayor submission, my lord.
Where is the proof? Because that was in cross-examination, you have clearly stated, I have not as further, I have taken loan from my people, and they are not the people that big rank loan, right? You have said all these things in your cross.
Yes.
That is why there was no such clear proof that you have invested 15 lakhs. But where from the trial court came the conclusion that it is the proof.
May I just stop it this way? admittedly, there is a check amounting to 15 lakh. Please allow me,
If I
just 2 minutes.
see, first of all, we are on the clear hand. There was a check issued by the,
So that will
it was a
presume,
blank check. Is the complainant have deposited, have up amount, have up everything is done. They are also aware of the law later on the capital. But when you are relying the agreement, and from 1st of April 2020, it has a clear indication. And this takes up not 2013, this takes up 2018. That is why you are asking, relying on clause 10 of the agreement and take and pay the case. Why do you want is that the police? Why not?
now,
We are don't expect to us. You are relying on the agreement. Agreement came into effect for 1st. Take it up. And
let us
it
read.
clearly says,
Yes, yes.
right,
Let me go back to the under this partnership. It says we have,
to read 100 times. Already you have pointed out
no, that's what I'm trying to explain.
Right.
madam. I'm just trying to explain.
your explanation is 9, there are 9, not 2. There are many sub-
9 says that they will approach the bank. And you see 9, they will approach the concerned bank to transfer it. Now, at that relevant time, that means it was
at the
in the name of
relevant
the
point of time.
proprietorship
That is
fund.
the reason why it is not 2000. The check is of 2015,
Yes.
and that is why the check clearly says authorized.
Madam, what is our evidence? We say despite our best effort, the accused did not cooperate. There is no evidence to contradict that. This is our evidence. Regarding proof, just allow me to cite one more judgment, madam. 2019-18 SCC 106.
Nine.
18 SCC 106. Rohit Bhai Jiban Lal Patel. Relying on para 18. I'm reading para 18, madam. In the case at hand, even after purportedly drawing the presumption under section 139 of the NI Act, the trial court proceeded to question the want of evidence on the part of the complainant as regards the source of funds for advancing loan to the accused and want of examination of relevant witnesses who allegedly extended him money for advancing it to the accused. This approach of the trial court had been at variance with the principle of presumption of law. After such presumption, the onus shifts to the accused, unless the accused has discharged the onus by bringing on record such facts and circumstances as to show preponderance of probability tilting in his favor. Any doubt on the complainant's case could not have been raised for want of evidence regarding the source of funds for advancing loan to the appellant accused. The aspect relevant for consideration had been so as to whether the appellant accused has brought on record such facts, material circumstances which could be of reasonably probable defect. Now that has been approved in Kalamani text by full bench. Yes, but yes, I'm saying my lord, this Rohit Bhai was approved in Kalamani in para 13, in para 13. Para, my lord, 13, 1, 3. Adverting to the case in hand, we find on a plain reading of his judgment that the trial court completely overlooked the provision and failed to appreciate the statutory presumption drawn under section 118 and 139. The statute mandates that once the signature of an accused on the check negotiable instrument are established, then these reverse honors clauses becomes operative. In such a situation, the obligation sits upon the accused to discharge the presumption imposed upon him. This point of law has been crystallized by this court and so and so. Then para 14, my lord. Once the second appellant had admitted his signature on the check, and the trial court ought to have presumed that the check was issued as consideration for a legally enforceable debt. The trial court fell in error when it called upon the respondent complainant to explain the circumstances under which the appellant were liable to pay. Such approach to the trial court was directly in the teeth of the established legal position, as discussed above, and amounts to a patent error of law. I'm trying to go through his evidence, my lord, at page of the accused at 115. And you see also his cross. His case is that I'm an employer and he issued the check to me. So he has issued the check. The question is for what purpose? That's only.
It's up to page 99.
Yes,
I have been working at
so and so.
MV Sotitapura. I have left the job
Over there for a period. Huh?
for
Prior
I
to
have
that,
left the job for there for a period.
Huh.
Prior to that, I worked some infra limited.
Bharati Info Limited.
Exhibit 1, not accounting year আসছে নাই not
Hmm.
exhibit 2 ওর নাম ইতে লিখিত আর amount ইতে প্রাইস
Hmm.
more advocate Victor Torot Asame reply A killer I do not remember if I have stated in my evidence but reply to legal
Hmm.
accused. I left the job at Mr. I have not in my evidence that false statement that I had joined the farm of the Data.
Hmm.
I had not in my evidence that false statement that I had joined the farm of the It is not a fact that I had kept the check for beer and to pay taxes. Assamie
Reply
I-
notice.
petition দেখতে মিসইউজ কৰিছে হৈছে আসামীয়ে কথাটো শুদ্ধ নহয় যে মই এভিডেন্স এফিডেভিটত উল্লেখ কৰা নাই It is not a fact that I have misused the text as alleged by it in my book. I do not know if my counsel got a reply from the accused regarding allegations leveled against me. It is not a fact that I did not know the witness of last by way of deed of ethics. মই নিজৰ লাখ টকা পাইছোঁ I have not started that
Stated the same in my.
in my evidence. It is not a fact that I have not used the same. I have not stated the same in my evidence. Tell me your copy evidence or evidence. লাচিত ডেকাৰ লগত 50 লাখ টকা কৰা নাই লোন কাৰ পৰা লৈছোঁ 10 মই এভিডেন্স কেছ ফাইল কৰা এতিয়ালৈকে মই চাৰিটা চাকৰি কৰা নাই It is not a fact that for my act I was terminated from RT. It is not a fact that I have not some enterprise of Karnataka has. I have not subjected, but I have not IT return service of market.
The appellate court recorded that there is not even a suggestion that I did not invest in the partnership business. It is recorded in my appellate court. Para 33, page 178. Can you just para 33 minus 178, just for a moment.
Please come to 130. Reply
113.
reply you will get in the earlier also. But the reply to the notice. Then your client being public made my client with allow him for
Hmm.
when my client is that really
Hmm.
my client is with for
Hmm.
relating is putting my client that the objective is my client is even though your client entered into an agreement work with my client because of the contract he has not yet any clear contract. However, the of the contract for this purpose it the best signature by now take that with cross I do not know of my counsel get a reply from KQ regarding allegations that so where from the appellate court came to know that
Name what much?
saying that there is no such suggestion.
In the cross examination, my lord.
The cross examination there is no suggestion.
There is no suggestion.
But in the reply he has clearly mentioned
In the reply, he said two things, my lord. That I am an employee.
clearly mentioned that he has not invested any amount.
He said, I am an employee. His investment is much less, my lord. He said, just an employee. He said, my lord, I am merely employee and he paid salary to me. In the same hand, he admitted his signature of the partnership deed. Trial court discussed that, my lord.
Mr. Reza.
May I please, Your Lordship, may I make some suggestion? Now, Lordship, learned senior counsel has stated that it is a case of blank check. The entire pivot of his case is that it is a blank check which was signed. But Lordship, please have a look at page 63, Lord. The complaint petition, Lord.
That you have put
Yes, Lordship. The accused issues check bearing number 16 is dated for rupees 15 lakh. Nowhere has it been mentioned it was a blank check. Neither in his evidence on affidavit.
but the honorable effect have get down. When you pay black card and it is
Yes,
that's
Lordship.
sufficient.
They might signature was admitted. But Lordship, the thing is that they had not raised the ground of blank check in the complaint petition or the evidence.
It's a contradiction.
Yes, Lord. There is no. And Lordship, one more thing, Lordship, please have a look at the partnership deed, Lordship. Clause number 15, Lordship, page 44. Or 15, Lordship, page 44. On the 6th day of January, on that day of every succeeding year, during the continuance of partnership, a general account of preceding year shall be taken and just valuation made of all assets and liabilities of the firm. Such general accounts shall be audited by registered accountant as the partners shall from time to time mutually appoint and shall be entered into a book and signed by both the parties. And when so signed, the entries in the book shall be binding on both, provided that if within 3 months of the date of the signing of the book any manifest error shall be found therein, such error shall be rectified. All profits after setting apart an amount as reserve fund to meet the emergent expenses and loss shall be divided as aforesaid after six. Here it clearly states that a book of account has to be maintained. But every expenditure, loss, profit has to be entered and it has to be verified by a registered accountant. So no such books of account has been submitted by the complainant. That is what I was pointing out. He is not adhering, he is relying on the exhibit one and he is not adhering to any of the points mentioned in exhibit. Even Lordship check authorized signatories, Lordship, in case of proprietorship firm, it is generally proprietor. Accounts where Lordship, there is a proprietorship firm, the authorized signatory generator and it is mentioned as proprietor in the checks of such account, not as authorized signatory. Because proprietorship firm and proprietor is the same person. Nobody can be a authorized signatory of a proprietorship firm except the proprietor. So if here on page 88, the authorized signatory clearly states that it's a partnership firm. So Lordship, the judgment of Veer Singh and Kalamani tax is not applicable in this from my side.
But may kindly see, Maharaj, this check was not issued towards any profit matter. This was issued in respect of my contribution. So here is no
Contribution has not
dispute,
been
my
proved,
lord, that there is
Contribution
some
had to be
profit or
proved
not
and
profit,
audited, Lord.
or there is some audit of the profit.
Lordship, that
We are not even going on the profit. It is my contribution.
of all assets and liabilities, Lordship. Capital is a asset, capital contribution.
Anything else? Pratap?
Lordship, please have a look at section 22 of the Partnership Act.
Act.
22, Lord, and section 19. Section 19 reads, implied authority of partners as agent of the firm. Subject to the provisions of section 20, the act of the partner which is done to carry on the usual way business of the kind carried on by the firm binds the firm. Then, Lordship, I'd like to go to section 22. In order to bind the firm, an act or instrument done or executed by a partner or other persons on behalf of the firm shall be done or executed in the firm name or in any other manner expressing or implying an intention to bind the firm. First, this is a check which has been issued from the Partnership Act. So, if it binds the accused, it also binds the complainant. In other sense, Lordship, the complainant has filed a case against himself, not against only the accused. Lord.
Want to say anything? Yes.
Lordship, my name may be recorded as Keda.
Data,
Keda,
not Esther.
not the senior counsel. Yes, sir.
Both of the
Yes, sir.
On the last occasion, I was supposed to bring the service report. Service report is here, Lordship can say this. But the service was made upon the mother of the respondent. But as per CRPC, it has to be served on a male adult member. But as per the new CRPC, I mean BNSS, that male adult member is removed and only adult member is kept. So as per the procedural law, Lordship can apply it even in the old cases. So I would say Lordship will see section 66 of the BNSS.
Was there any male member?
Because she is married now, she has her mother and father, I'm not sure. They have taken the signature of one witness and the mother. The Lordship will see the BNSS section 66. I think procedural law will cover even in old cases.
Up-
Lordship will see it was served upon the mother.
Right.
Served. Okay. It was served on 8. 26th
26th of July.
July. Oh. How can you? Oh, 26th of July.
Difficulty is but the ASI.
Huh.
Quite of that there is no date.
I think on the covering letter.
But it's the number by which
Lordship will see the first page of the course title, and there it is written 26/7/2024. No, Lordship, this is the one. Oh, that my office has received. I'll ask him how he, perhaps there will be an envelope over that.
my foot.
No, one person came and handed over. That I know. Special messenger came of Bhagrapar police station and handed over.
Moreover, Lordship, we have taken 5 times. We have taken step 5 times.
In my humble submission, that is considered as service done. Admittedly, it was served upon the mother of Aklima Khatun. Date is there on the first page.
Can I?
No.
Kita ini very simple. Pasti nak mother of itu ya itu.
Admitted.
Yes, sir.
Etc.
Appeal is admitted on 22/12/2020. LCR was called for, LCR also.
What my learned friend had pointed out is that the mother is actually the informant, but they have made victim as respond number 2. The mother had lodged the ejahat. So in that case, service is okay. Only
Hasina, sir.
Very
LCR receipt for here.
State,
Lordship for bail.
petite. Text or what perhaps getting,
So kindly short date may be given in the meantime.
I think it's a 2026.
That bail for bail lordship short date may be given.
Then I'll file my objection, 10 years. Oh, objection is given after.
Objection has been
And does the
Yes, sir.
faculty-
I have
You file your objection.
I filed. Yes, yes, I filed.
we have taken
Objection has been
Anjuara
filed.
Begum has filed, not me. Yes. Then on the next date, bail application
Yes,
can be
sir.
taken. So, and one more issue, an amicus has to be appointed for, or otherwise, if they come with their respective counsel. Now, the service is only completed on 26. So they might also come up with their own counsel, but will.
Because of incomplete address not found, and thereby it has been returned to sender. Furthermore, your lordship, service report is yet to be received from the district magistrate Kamrup. Your lordship, we have taken steps on the address that has been provided in the complaint petition, your lordship. If your lordship purchases the complaint petition at page number 16, your lordship.
Pune, presently residing at Soikong.
Yes, yes.
Jurisdictional magistrate's order is awaited. Can await for some more time.
What,
Yes, your lordship. Appearing on behalf of Mr. TW.
Or Lordship has ordered for press service. Press.
Your Lordship, I also pray that there is an interim. There is an interim which was granted on 11/6 to much obliged, Your Lordship.
My lord, service upon respondent number 2, it seems, my lord, over, my lord.
Number 2 has appeared.
My lord, personally, he appeared. So last two occasion, petitioner did not appear, my lord, because of the wrong impression that my lord, matter would be taken in the month of August.
Not be appearing this time.
Yes, my lord, for the petitioner. LCR will be there.
Are but yeah, it is the by order direct. Order. Third is not the report of
33 वाला कहाँ है?
May I say, my lord, September 6th, my lord. My lord, interim order. Bibliography. Page 2, faithful people, 2000. Yes, yes. Right.
So we have taken statement. If you're met with Lord, in this case, my Lord, I've been led by Mr. Pankaj Sharma, my Lord. He has some personal inconvenience today, my Lord. Has requested. He has some personal inconvenience today, my Lord. It's this case can be taken up on 6th, my Lord. By this time, probably, my Lord, the service report will also have. Not pretty Lord, keep it. Sorry, keep. Take the focus. My Lord, will keep in early date, my Lord. There is some urgency, my Lord. Basically, the keep the 30 days, right? That's not the focus. And take out by my Lord, let the Mr. Sharma come and address this on the my Lord, there is some urgency in this case, my Lord. True, but it is have to have the record the report. So last is back last week on last Friday. Taken steps, my Lord, before. We have taken steps. It is considered 7. My Lord, will kindly on that some date on the month of August, my Lord. Based on the date of my Lord, 27th of August, my Lord, if it is convenient. My Lord, I am at it's 6th of September. My Lord, 6th will be little late, my Lord. If it can be late, one to if it will be difficult. Well, I will try, my Lord, because I am Mrs. Sharma. You are not a postman. Mrs. Sharma was a lawyer. Second or third, I will feel so much pressure with the client. True, but we have the option. Even if it it's a nice, my Lord, please. Nice. Oblige.
This is that matter where second 482 application, whether it's maintainable or not. I've gone through the judgments, few of them, which are most leading judgments on the point. What I finally find is that it all depends on the facts of the case. Because Lordship will say Visham case, Lordship had seen on the other day. Visham case, the facts are like this. The project of the the SMS pharmaceuticals also have gone through. I'll tell about the facts. First of all, I would just like to point out Visham's case. Visham's case, what happened? The joint director, he had lodged a complaint against the project officer for embezzlement of money with regard to some project. Initial 482 application was filed only on the ground that sanction was bad. Sanction by the government was bad. Then in that proceeding, the government advocate submitted that they can raise the issue before the trial court. So then that case was disposed of with a direction that they will raise it before the trial court. Then they raised it. Thereafter, nothing happened. And then the second application was filed, challenging everything, charge sheet, proceeding, everything. But there the Honorable Supreme Court said that these facts were known to the petitioner on the date of the first application was filed. And so after taking recourse to amicus curiae submission and all, they said that 482 application second time will not be maintained. So that was not a case of withdrawal and all, that the case was dismissed, disposed of on merits. Known. Yes, applicant. Yes. Nothing happened. First, yes, those were not taken. Yes, made. But then there are other judgments where even those facts which were known to the petitioner were not considered to be fatal, and then they heard the second application. Lordship will see the second case that I would like to place. Superintendent and Remembrance of Legal Affairs, that is also a leading case, 75 case. Fisham case. I'm not serially pointed, I mean, I've just taken. The citation is, it's not reported in SCC, but I can, it's reported in Supreme today. No, SCC citation I did not get there. Yes, this is Visham. They have given so many of them, even AIR they have not given. Visham, VHISHAM. I can mail it, Lordship. Acha. Visham Lal Verma. Separate what? Separate. All separate. Visham, then Lal, then Verma.
VAR or VER?
VERMA.
BH, no?
Yes, BH, B for Bombay. BH. Lordship got the judgment. Lordship will see that these are the facts. And paragraph 22, Lordship will find No, not paragraph 22. This is the last. Yes, state of UP. Paragraph 12, it is said, the last but second paragraph. In the case at hand, the filing of the charge sheet and the cognizance thereof by the court concerned were well before the filing of the first petition under 482, wherein challenge was made only to the sanction order. That being so, the petitioner was not at liberty to again invoke the inherent jurisdiction of the High Court in relation to the charge sheet and cognizance order at a later point of time. The impugn order passed by the Allahabad High Court holding to this effect is therefore incontrovertible on all counts and does not warrant interference. So that was the main ground of rejection. Lordship will see the next case. This is 75-3 SCC, that Mohan Singh's case, which is the leading case on this point. Of course, then it was not 482, it was 561A. 75-3 SCC 706. 1975, 3 SCC 706. This is Superintendent and Remembrancer of Legal Affairs versus Mohan Singh. Lordship got it? Where the facts I'll tell, Lordship need not go into. The facts are like this. There was a negligent death of a lady, 304A. Then what happened? The revision was filed for quashing. And then the High Court said that this will involve question of facts. And so we will not go into, and the High Court dismissed the 482 application, the first one. Thereafter, nothing happened in the trial court. Then second application was filed for quashing. There the High Court quashed and state went on appeal before the Supreme Court and the point raised. So the legal remembrancer versus Mohan Singh. There the Honorable Supreme Court said subsequent petitions will be maintainable in given facts. Again, in given facts. No. Hmm.
But in the trial, nothing happened.
Many years
Long
passed.
period. Let us see that there will be the
Yes, paragraph 2, last part. I have in fact seen. Paragraph 2, last part, Lordship will see. Because first application was filed many years back. And thereafter again another one.
didn't happen. But
Yes.
that that is the
Yes.
Refused to quash.
Review was filed for quashing. Revision.
First one was refused to quash. And ultimately, there is a finding.
Finding that it is question of facts involved, so High Court will not enter.
Yes.
On that,
Cannot-
they have
Cannot-
dismissed
cannot-
it.
Cannot review the order.
Cannot dismiss. Thereafter, they went on for a second application and there High Court went into, and then the second one, the quashed. So the
That-
state went on appeal.
what
Lo-
happened?
Yes,
When matter is
Case
at
did not progress, did not, nothing happened.
nothing happened. Yes. Lordship is
So-
reading paragraph 2.
So up from 1975,
Hmm.
March,
Hmm.
nothing happened. So the first,
Yes,
the-
approach.
this is the back.
Huh.
That this time,
and when matter is adjudicated, earlier adjudicated in return, cannot review his own order.
Lordship will see the last part of paragraph 2. I'll just read this. Here the situation is wholly different. The earlier application which was rejected by the High Court was an application under 561A.
read from para 2.
Plus 2 is a long paragraph. Lordship starts.
Just-
I'm reading
just-
from Supreme today. Lordship paragraph starts from with the words.
Then
You belong.
Huh.
That's the final.
Yes.
Let's start.
Here the situation is little different because I'm reading this paragraph after our discussion was made on WAPI 561A. Review an earlier order. The question is to scope and ambit of 561 vis-a-vis an earlier order. Mr. Mukherjee cited in 3 judgments, Raj Narayan, Lal Singh, Ram Ballabh. It is, however, not necessary for us to examine the Lordship got it? Yes. It is, however, not necessary for us to examine the true effect of this observation as they have no application, because the present case is not one where the High Court was invited to revise or review an earlier order made by it in exercise of revisional jurisdiction. Here the situation is wholly different. The earlier application which was rejected by High Court was an application under 561A of Code of Criminal Procedure to quash the proceeding, and the High Court rejected it on the ground that evidence are yet to be led and it was not desirable to interfere with the proceeding at that stage. But thereafter, the criminal case dragged on for a period of about 1.5 years without any progress at all. And it was in these circumstances that respondent number 1 and 2 were constrained to make a fresh application to the High Court under 561 to quash the proceeding. It is difficult to see how in these circumstances it could ever be contended that what the High Court was being asked to do by making the subsequent application was to review or revise the order made by it on the earlier application. Section 561A preserves the inherent power of the High Court to make such order as it deems fit to prevent abuse of the process of the court or to secure the ends of justice, and the High Court must therefore exercise its inherent powers having regard to the situation prevailing at the particular point of time when its inherent jurisdiction is sought to be invoked. The High Court was in these circumstances entitled to entertain the subsequent application of 1 and 2 and consider whether on the facts and circumstances then obtaining the continuance of proceeding against the respondents constituted an abuse of the process of court or its quashing was necessary to secure the ends of justice. The facts and circumstances obtaining at the time of subsequent application of respondent number 1 and 2 were clearly different from what they were at the time of the earlier application of the first respondent, because despite the rejection of the earlier application of the first respondent, the prosecution had failed to make any progress in their criminal case, even though it was filed as far back as 1965, and the criminal case rested where it was for a period of over 1.5 years. It was for this reason that despite the earlier order dated 12th of December 68, the High Court proceeded to consider the subsequent application of respondent number 1 and 2 for the purpose of deciding whether it should exercise the inherent power. So the main reason was taken was the delay. The case never progressed. Yes.
So for that,
Did not read.
but enough to 1.5. Witness was not recorded. That's the top.
Yes. So all depends on facts. So I'm placing facts, whether our facts will also
No,
be
we
regarded
have,
as an exceptional.
Whether it is Jamlal Verma or
Yes, remembrance, sir.
right.
SMS format.
It's the effect of the fact.
PSFD case. The third case, Lordship will see this SMS Pharmaceuticals. SMS Pharmaceuticals is 2007 4 SCC 70.
There are 32. 32 and
SMS,
28.
Lordship got it, 2007 4 SCC 70. There the facts are like this. Check was dishonored, complaint was filed. Then discharge application was filed for discharging the applicants. That was dismissed. Then 482 petition was filed against that. That was withdrawn. And then again they filed and it was heard and it was disposed of. Here the question comes is withdrawal of the application. Lordship will see paragraph 28. First they filed it and they withdrew, and thereafter they filed it again, and it was heard. My 28 paragraph starts with another submission of Mr. Mishra. Lordship. Because from here, second application, whether it is maintainable or not, was heard. Lordship, another submission of Mr. Mishra. Another submission. Yes, paragraph 10 is Lordship, paragraph 28. I'll read out. Another submission of Mr. Mishra was that the second application was not maintainable. Such a question had not been raised before the High Court. Even otherwise, the High Court was not denuded from exercising its inherent jurisdiction in a matter of this nature. The principle of res judicata are not attractive. Reliance placed by Mr. Mishra on so-and-so case 92 is misplaced. The question which arose for consideration therein was to whether, despite dismissal of an earlier application, a second application would be maintainable, which would virtually amount to review of the earlier order, which would be contrary to the spirit of 362 of the CRPC. Lordship? Paragraph 5. Before that. Lordship. Paragraph 5 starts with
The third portion.
yes, it was not, even if it was raised, that is what it said.
If
Paragraph 5, Lordship, in the said proceedings, a petition for discharge was filed. Lordship, I'm reading it correctly?
correct.
Yes. For discharge was filed by respondent number 2, which was rejected by learned trial judge. A revision petition filed there against was also dismissed by learned session judge. An application under 482 was filed questioning the said orders, however, was permitted to be withdrawn by the High Court, stating, the learned counsel for the petitioner seeks leave of the court to withdraw this application. The same shall accordingly stand dismissed as withdrawn. Leave granted to the petitioner to avail the remedies, if any, available to him in law. This is not the case here. This is, of course, not the case.
That's the fact.
Here, notices were also issued once. But the matter is that, but the
Now there are
Lordship. Paragraph 10, the answer to the question, Lordship, can go to 28. These are all on 141. 28, another submission of Mr. Mishra was that second application was not maintained. (29) is also relevant. 29, we have noticed the previous order passed by High Court. High Court gave liberty to respondent number 1 to agitate the matter once again. That liberty is not here. Respondent number 1 merely took recourse thereto. Equally placed is the judgment of Rajendra Prasad. Wait. Only Rajendra
if when adjudicated, I think not adjudicated. The success of this SMS Pharmaceutical Limited, saying that, my lord, when matter already been adjudicated within the party, and there is an order, and then principle of res judicata is affected, then not maintained. And it is in my case, my lord, matter already been not adjudicated. question of my lord, subjudice. Doesn't there? Whether they are prejudiced, I think it's there. And if earlier order refused to pause the proceeding and the Honorable High Court cannot entertain second application, otherwise it will tantamount to review of its earlier order. I am not seeking to review the earlier order. Thus, notice was put and without taking a step, and therefore they also could not appear in their case, and therefore question of res judicata does not have. But was not judicata. That is stated under para 32 in SMS pharmaceutical case. If we refuse to quash earlier case, and subsequently again if application filed to entertain that order, ultimately it will be tantamount to review. The court has no jurisdiction to revise the order. My case, you can't propose. No review or revision can be affected.
Yes. Yes. 30, it is said, it is therefore an authority for the proposition that the High Court is not completely denuded of its power to exercise inherent jurisdiction by taking into account all these judgments. Although therein it was held that when an earlier revision application under 397 has been dismissed as not pressed, a second application under 482 thereof for grant of same relief should not have been entertained, this court opined. We are of the opinion that no special circumstances were spelled out in the subsequent application for invoking jurisdiction of 482 and the impugned order is liable to be set aside on this ground alone.
Why did place that
That reason they have to show.
That-
Because here also in that same decision it is said, they had simply taken recourse to what the court had said, that liberty is granted. So they had taken recourse to and they had filed.
so, that's how it
That's how that. This is there. And one decision I want to show to, in order to show that even the facts which were known to the petitioner while they filed the first application, even that may not be fatal at all times. That is Anil Khandikwala, 2019-17 SCC. 2019-17 SCC 294. There what happened?
That is on record.
Asan, eh?
I have furnished already.
Okay, okay. 2019-17 SCC 294. Anil Khandikwala versus State. There the facts are like this. Complaint petition was filed. Summons were issued by the trial court. And and the first application was filed on the ground that signatures on the checks were his, but then he retired before that, the petitioner. That was dismissed, saying that no, his signatures were there, so that is the end of the matter and he is liable. This is for 141, 138 case. Thereafter, a fresh application was filed. There what happened, they placed Form 32 showing his resignation letter. But this Form 32 was available to him during the first, while he filed the first application. But then the Supreme Court said that this form was not placed before the court. And so that becomes a new fact. And then it was heard. Lordship will see paragraph 7 of that judgment. Paragraph 7 of Khandikwala. The complaint filed. Paragraph 7 tells us the complaint filed by respondent number 2 alleges issuance of the checks by appellant as director on 2001, February. The appellant in his reply dated 31/8 to the statutory notice has denied answerability in view of his resignation on 2001, January. This fact does not find mention in the complaint. There is no allegation in the complaint that the checks were post-dated. Even otherwise, the appellant had taken a specific objection in his earlier application under 482 that he had resigned from the company on 21/1/2001 and which had been accepted. From the tenor of the order of the High Court on the earlier occasion, it does not appear that Form 32 issued by Registrar of Companies was brought on record in support of his resignation. The High Court dismissed the quashing application without considering the contention of the appellant that he had resigned from the post of director of the company prior to the issuance of the check, and effect thereof in facts and circumstances of the case. The High Court in the fresh application under 482 initially was therefore satisfied to issue notice in the matter after noticing Form 32 certificate. Naturally, there was a difference between the earlier application and subsequent one, inasmuch as statutory Form 32 did not call for consideration by the court earlier. Now, he said he resigned. 42 was not clear.
Now he had motor satisfied it.
Form 32.
Not that Form 32.
Mm.
From the
Before the.
prior to the issuance of the.
But perhaps this Form 32 will be available to him whenever, the moment he resigned.
It was not considered.
Not considered, not placed, not.
Not placed, was available, not placed, not. Now, it is not be reviewed. So they filed it as a.
Yeah. Considered.
The counsel for the. There are considering that fact that this was not just I put what I that the
Mental support.
that the Philip was not so it varies the fact of
Bit very.
if the petitioner can show the reason for approaching the High Court under 42 for second time, then the question of fact is different. That is a bit difficult, but has to be established by the petitioner first why he had to approach.
Lordship, I filed additional.
Reasons and everything.
I filed, my Lordship,
Otherwise, it will amount to suppression of fact. He had in fact not
And in
stated.
fact, he is having all the knowledge
Huh.
of that particular new term that was already available. It's not that it was not to him.
Lordship, here, my Lord, in this case, so far, my applicant, paragraph 7, therefore cannot be said to be repeat application. But on the same fact, I am not repeating, but so far my additional affidavit is concerned. New fact, my Lord, 10th fact is Here, during the pendency of this case, my lord, subsequently, my lord, another abuse of process, the executive magistrate, judicial magistrate issue another summary, the same thing. Page, my lord, 55. It's my lord, applicant, my lord, change circumstance, my lord.
There is also after hearing,
Hmm.
it's not a case that is withdrawn.
No, no, after hearing.
After hearing,
That means
After hearing.
adjudicated.
That was adjudicated.
that was after hearing, it was, and then it was,
Hmm.
that is why again came,
Hmm.
today from 30 was not possible.
Yes.
There is,
Yes, withdrawn.
it is, there,
Withdrawn,
is
of
not a
course.
case
Hmm.
that where matter was considered that was
Hmm.
right, and that to
Hmm.
be left out,
Were not paid.
not been brought to the
Hmm.
court, somehow could not, but that no review is possible. That's how, again for it,
Again for it. That can be a
that
case.
And lordship,
here withdrawn,
Withdrawn.
30 leave of
Yes.
but lordship, so far, my lord, mention memo is concerned. Mention memo is concerned. I have mention memo, it was withdrawn. And in mention memo, it was written, liberty is to be given. But
Momo cannot be a part of it.
But question is, my lord, the honorable court saying that our initial stage and matter has not been adjudicated in the party, so liberty not necessary. This is the case. So, to proper court, maybe then, my lord. So, which court
says that,
which court? The order.
which court says that liberty without leave, that party will come back.
Which court? Order I took. Order. Order.
No, we have the second point.
One page.
Withdrawal order is a bypass stating it for
And so far, my lord, my additional affidavit, lord, here, my lord, this document was not available when first application was filed. This, my lord, agreement, deed of agreement. And hereafter, my lord, I obtained this certificate copy, and this is the same circumstances, lordship. The
Mr. K. Bhuyan, Learned Counsel for the petitioner, submits that he has the instruction to withdraw this petition.
lordship.
Accordingly, as paid for this
And I thought for liberty because this document was not available. Only this petition, my lord, I supported this document, the deed of agreement. And deed of agreement itself saying everything, my lord, 27/11/2020. It was not with my, and therefore I relied upon this deed of agreement and page, my lord, 61. This is, my lord, same circumstances, my lord. This is a part of this criminal petition number 325. And I relied upon on this document. This document was not available. And now, my lord, when I come to the second application and gone through the record, this document was available, and from that document I received this. And therefore, my lord, immediately withdrawn, and subsequently this. And for the petition, my lord, same situation. Both the criminal petition arising out of two cases, my lord. One on the same date, filed two cases, my lord. One, my lord, NI case number 153 and another 154. One claiming 48,91,000 above, and another lordship 1 crore 60 lakh. And two cases filed on the same date, my lord, and cognizance taken. But there is no any reason, satisfactory reason appeared in the summoning order. So one of the Supreme Court says when there is a abuse of process, my lord, and when no reason is given there in the summoning order, then that order cannot be survived and can what? The case. And if there is a merit, then for it is a second application. And this all this thing I relied upon. Not as it is. The earlier application and this second application is not quite different, my lord, paragraph, quite different ever. Not if I file as it is earlier one, then not maintained. But the pleading is completely different. Down also completely different. When ground is completely different, fair also different, not as it. And I am not picking any order which already passed by the zonal court to review that order, then not maintainable for it. Second appeal. So far SMS pharmaceutical case is concerned, then if review its earlier order, then for it to do. And as earlier application was not adjudicated in the party, the penny initially is withdrawn. And it is maintainable. And pleading also quite different.
So you have to discuss, you said regarding the agreement.
Yes.
Agreement was not taken into consideration.
No, agreement was not placed in first.
Agreement was not placed.
Yes. It was not available with me, my lord. And that is why in this case I relied upon only this document.
That's
This document will say everything.
you have submitted reply to the notice.
Yes, lord.
We annexed it
In second application, my lord.
in one time.
Yes. Page 29. Lord. Second application. Reply was made.
Page 56 is the notice. That's page 7.
26.
So
So,
this
26 is the notice. Lord.
That 27 have applied. So reply is of 28th of October 2021.
Yes.
We have talked about the agreement
Okay.
of 2711, which according to you was not there in the earlier.
Because
Right.
this agreement was not available because it was
You are aware of the agreement, whether available or not available, that is not.
not that right. But I was aware of, my lord.
You are aware about the agreement. You said in the first application, you have not talked about the agreement. Now, this particular reply, this reply 2021, next 5 was annexed in the earlier and at paragraph 3, the earlier petition. You have talked about the agreement. Paragraph 3, subparagraph 3. You have discussed about in paragraph 3, subparagraph 3, you have discussed about the agreement. In paragraph 4, you have discussed about the agreement.
But this agreement copy, my lord.
The records before us, paragraph 3 of the earlier petition. You have mentioned
But this
that in
agreement,
the reply notice, it has contained that in terms of agreement 2711 enter to the responsible one.
lordship, LCR revealed, my lord.
See,
In
please
criminal petition number, second petition, my lord, the LCR shown.
why should we interfere in the count,
Lordship,
or you have to establish? You say that the first you have not talked about the agreement that count. Yeah. Discuss. You
lordship,
have said
let me
in
submit, my
your
lord.
reply to this, you have
Lordship,
said about this agreement. You have taken that count in your petition earlier.
lordship, criminal petition 819 arising out of, my lord, NI case number 153. And cognizance was taken on 26/4/2020. And then I received this agreement copy. Because agreement, I was aware, but this agreement original copy was available with
Yourself
and lordship,
pursuant
this
to the
record,
agreement. Yeah.
819, my lord, LCR kindly have a look, my lord.
It is your
Only,
agreement.
my lord, LCR 819 this agreement is available. And so far LCR 8329, this agreement is not available. And this agreement, my lord, only enclosed with second application. And therefore I come to know and immediately I file this additional.
The rules of that you have entered into an agreement independent of the have already made an of 1 lakh the after the next.
And
How will you say that you are not aware?
and so far, my lord, and so far, my lord, page number 56, my lord. In my lord, additional affidavit 329 case, criminal petition. And here, my lord, again, during the pending of this case, again, this harmony. A bit of case number, my lord, 154. And this criminal petition 329 arising out of NI case number 154. And this notice issued on 26th of April 2023. It's the same circumstance. I also can challenge this summons. And my lord, two NI case file, one claiming 48 lakh above, another 1 crore 60, but the summoning order doesn't reflect the reason of taking court. And so far, my lord, I relied upon my lord Pepsi Food Limited, and that has been also full bench decision recently passed, my lord, on the Supreme Court.
That was not good job there.
In my lord Sunil Bharti Mittal case, my lord, full bench decision, that also my lord reiterated this Pepsi Food Limited. When cognizance is not taken properly, then my lord, abuse of process and complaint, my lord, in this case, allegation made in the complaint are patently absurd. And then, my lord, this court can extend this petition for quashing this. Otherwise, so far Pepsi lordship, this case is concerned, SMS pharmaceutical, if review the order, then tantamount, my lord, own order. I am not taking that earlier order to be. That is only one line order. But we are in this case saying that if earlier refused to quash the proceeding, and again 482, how can it be? Otherwise, it will tantamount to review own order. That is the case. No review or revision can entertain by the court. So for 10 circumstances here, that is, my lord, I satisfy this on court because so far summon is concerned, subsequently doing summon when the petitioner already entered the hearing, he was allowed to go on bail. And matter is, my lord, at cross examination case, and even between case 55. This is the original. The cross examination. No, if found a 10, then ultimately one. But the LPR available. Each and every day found. Very interesting. The case was filed, your lordship. But if the second application is maintainable so far SMS pharmaceutical case is concerned, has not tantamount to review. And so far, my lord, earlier, yes, few days ago, I realized this case, my lord, Pepsi put detail. And now today, my lord, I would like to let upon this Sunil Bharti Mittal, my lord, full based section. And here, my lord, the paragraph 18 also reiterated the Pepsi Food Limited case.
Why you have said the cognizance have
Cognizance, my lord, without application of mind, my lord, generalized observation,
is required?
general observation. But
Cognizance, which law provides while taking cognizance?
here,
that
my lord,
order and space
this full pen decision saying reason is to be mentioned. The order is that, my lord, paragraph 47 in my lord Sunil Bharti Mittal case, full bench decision, saying that the order is able to be set aside if no reason given there. Only, my lord, generalized observation.
There is. Are such
While coming to
those
the conclusion
cases-
that there is prima facie case against the accused, the reason is to be there. Because what the case, one consisting, my lord, 69 lakh, another 1 crore 60 lakh, and there is an agreement, my lord. Agreement itself saying the check was issued in the year 2020.
that's
But if AIR 2015, Supreme Court 923.
You're talking about the Sunil Mittal case.
Yes, Lord. There are page 9 to full transition. Saying the sufficient ground for proceeding under section 204 suggests formation of opinion on after application of mind, and on basis of sufficient material, such formation of opinion to be stated in order itself. Summoning appellant as accused without recording proper satisfaction by special judge able to be set aside. It's the law, my lord. And paragraph, my lord, there are 18, my lord. There are 18. There are 18, my lord. It is reiterated regarding, my lord,
Within 2015, 609.
and paragraph, my lord, last paragraph, my lord, 47, my lord. And lordship, logically, if we see, my lord, in both the case, one NI case number, my lord, 153 and 154, 153 and 154, both case was filed on the same date, and cognizance taken in the second case, my lord, regarding 1 crore 60 lakh 78,996 on 26/4/2020. After a long gap, that is after thought. Judicial magistrate at the same date, both the case filed. But first one, my lord, taken cognizance on 12/11 to 2021, and cognizance taken on 19/10 to 2022. But second case, which was also filed on the same date, 12/11/2021, but cognizance taken for a long gap, 26/4/2020. Because the second case appeared this agreement, And after thought, because of 1 crore 60 lakh without having any supporting book. And when encashment, when deposited the check, whether this amount exists, because over one of Supreme Court recent decision, Dasharath by Tikambar Patel case, my lord, saying that when encashment and when deposited, whether this legally enforceable debt is exists. And there is no such averment. For the complaint, there is no averment. Then when these two checks deposited, whether on that date, this huge amount, more than 2 crore 97 lakh total, whether exists. The one of Supreme Court says recently, Dr. By become by that is not there. Abuse of process, my lord, unnecessary harassment. So on record, healthcare already available, my lord, on record saying that this check was security check, total 5 number of checks was given. And there was no any maturity date when it to be deposited. There is no such stuff. And this agreement also, my lord, there is a arbitration clause. There is arbitration. In that also, this clause has not been availed. And by putting his own way, this huge amount deposited and ultimately to come. And the learned magistrate also not mentioned the reason why this amount is available at the time of death. Reason is not issuing mechanically.
But the summon order is not a bold statement. Lordship, if you see page 50, the complainant present submitted his evidence on affidavit SPW1 along with some documents that he has relied upon. The documents have been proved in original, originals are returned. Peruse the complaint, evidence on affidavit. On perusal of the complaint and evidence on affidavit, a prima facie case is found.
This is judicious mind.
It's judicious mind. It cannot be a bold order. It's not a bold order or anything without application.
No, one of the Supreme Court says in
What happened?
Hmm.
It was
Yes.
But while these persons are found to be there, but control. That is why they are already in their control. And being aware of everything,
Company.
But they found that's how. But they were not.
Yeah, not that.
But after there is that first last that
I'm trying to find out the summon order here, but they have not reproduced it.
now, my lord, this point is to be very important. Lord. When on record, healthcare itself revealed that there is an agreement, and that has been suppressed in both the complaints. Not this complaint petition, my lord, paragraph 5.
Please come to page paragraph 53 of
53. No, Lordship, the paragraph. I think 45. On the other hand, section 204. A wide discretion was given.
that's here.
However, the vote sufficient grounds for proceeding appearing in this section are of immense importance. It is these votes which amply suggest that an opinion is to be formed only after due application of mind, that there is sufficient basis for proceeding against the said accused, and formation of such an opinion is to be stated in the order itself. The order is liable to be set aside if no reason is given therein, while coming to the conclusion that there is prima facie case against the accused. though the order need not contain detailed reason. A fortiori, the order,
That was a document
yes.
required. Just 3 line
Hmm.
cognition will not be. It has to take has that basis at which the prior to budget has to show that
Something to show where a prudent person can make out.
this order clearly repeats. Yeah,
Exercise. He had gone through the material. He had seen the statements.
And Lordship, the one of Supreme Court also there.
and the perhaps it's very clear.
Hmm.
It is there
However,
are two parts
huh.
that order.
However, the words sufficient ground for proceeding appearing in section are of immense importance. It is these words which amply suggest that an opinion is to be formed only after due application of mind, that there is sufficient basis for proceeding against the said accused. And formation of such an opinion,
This is
yes,
and the formation of that order.
huh. Yes, formation of such an opinion is to be stated in the order itself. The order is liable to be set aside if no reason is given therein, while coming to the conclusion that there is prima facie case against the accused, though the order need not contain detailed reason.
In fact, I have not answered this, but I
Long one.
because earlier there
Hmm.
are
This is very mechanical.
very mechanical. In that particular, there was like very clear that that part, exercising part was not there. Here it was.
Hmm.
It appears that
Too far. Yes.
to show that we established before while speaking that topic to what get done. Here in this particular that the
Hmm.
and that
Hmm.
thereafter here
There are documents also he has to see.
And Lordship, how he can satisfy, because Lordship, page 15, the allegation, my Lord, some amount investment, very clearly stated, the complaint. The judicial bench, how it can satisfy against some amount, how it can be 2 crore,
that evidence
how it can be 2 crore, because it's clearly saying that investment of sum of his money, the sum of his money doesn't say that 2 crore. And my Lord, paragraph 3, page 15, very clearly saying the sum of his money investment. And very false statement saying, so far agreement saying the check was issued, date clearly mentioned, my Lord, on 27/11/2020. LCR is still reflecting, my Lord. 27/11/2020, the check was issued. But here there is a false statement, page 16, that on 2/8/2021, the check was apparently, my Lord, clear and patently observed illegal. Looking into account. Because document itself, his document, this is not my document. The respondent number 2, in the second application, this document fine. But in first, my Lord, case, here saying application complaint page paragraph 5, my Lord, saying that the complainant back to state that as the complainant kept insisting the accused to make his aforesaid payment on 2/8/2021, the accused issued a check to the complainant of amount of rupees so and so, check number 22244. On the agreement, this check number was there, 22244, and it was issued on my lord, 27, 11, 20. But here it apparent APR, the fourth step. It is my lord,
With regard to 329. Pass out.
And
The
one more thing,
another-
in this application, he had not mentioned about the first application. What had happened? It amounts to kind of suppression of.
No, there is not
Yes,
adjudicated.
Mahajan, with regard to
That was not adjudicated.
Withdrawn. I can see it, but
No, even because no, not adjudicated, no finding was there. The initial stage it was withdrawn.
at least those facts.
Material, if material I suppress.
Yeah.
Here,
To you.
Maybe it's not on 329 on maintainable also it's already seen the judgment. It's already seen the judgments, my lord, based on its in that SMS, my lord, pharmaceutical case, I only want to point out one thing.
if this maintainability issue and second application,
2007, yes, 174 is 70. But there, my lord, I am seeing from India, I don't have paragraph numbers, my lord. What the Supreme Court has said, my lord, we have noticed the previous order passed by the High Court. The High Court gave liberty to respondent number 1 to agitate the matter 1 second. Respondent number 1 merely took recourse there.
That is
The lordship is seen, my lord. And my lord, in this, I can't find the paragraph right now, my lord, but the Honorable Supreme Court has said that the petitioner here therein in SMS raised the issue of maintainability for the first time in the Supreme Court, my lord, and not in the High Court. Therefore, after the Supreme Court came to a finding on merits, now raising a question of maintainability, not proper. That was possibly the finding in SMS. There is no paragraph number, my lord. I beg my lord's pardon, my lord. And the rest, my lord, there has to be material change in circumstance, my lord. Well, material change in circumstance, I tried to find out a definition for that, my lord. In family law, I found, my lord. Black's dictionary, my lord, the definition of change in circumstance. So this is in reference to, on the right hand side, my lord, bottom part, my lord. The fourth on the bottom. Yes, my lord. That is in relation to family law, my lord. What I'm trying to place here, my lord, in criminal law, in our understanding, my humble understanding, my lord, what would be a change in circumstance, my lord? Charge sheet is filed, a new ground, my lord. Copy is furnished. Going to the copy, my lord, I find that it is not a case of 302. Postmortem says natural death. My lord. Charge is framed. I come against the framing of charge order, my lord. Those are changes in circumstance, my lord. Not taking up a ground which was available to me in the first instance would not be a change in circumstance, my lord. When I fully am aware regarding that ground, my lord. And that is what Vishamlal Verma says, my lord. That there is no blanket rule. There is second petition is not maintainable. But it would depend on your own facts and circumstances. And there has to be a marked material change in circumstance while moving the second application for it to be maintainable. And here in Malo, nothing is mentioned that this is the material change circumstance. That is my humble submission. As regards the maintainability in 329.
So change in circumstances is equivalent to change circumstances.
Change circumstance. Well, something has to change, not a ground mind. This Supreme Court authority I came across. That is a new ground. That cannot be a change circumstance. Law is that cannot be a change circumstance. Ignorance of law that I always be here, for an excuse, that cannot be taken as a change circumstance to move a second criminal petition. My humble submission is petition 329 criminal petition. The first one is not maintaining. Everything in the second petition was known in the first petition. Even the paragraph I can show that they were similar. Wording has been changed here. In what they're challenging is the same thing. And paragraph 9 of Satyamlal Verma. The last part of para 9, the submissions made by the learned amicus there, he also drew our attention to R. Annapurna. To the theme. So and so and so. So in a quash petition of 482 was dismissed on 28/1/1995. Without mentioning the same, another petition was filed under section 482 CRPC with a similar prayer, noting that the second petition was not made on the strength of anything which had developed after 28/1/1995, but only on the fact which subsisted prior to that date. This court held that the second petition was not maintainable. Here, same thing, they have, whatever they have challenged in the second petition, they have challenged in the first petition. Ramagat, Ramadubu, 2010 SCC 4 years. Okay. Yes.
that the heart.
Yes, okay. Only supporting the 10 is 40. That is all.
Lordship, so far, Anil Khanwala case, I relied upon that I some so that about that he knows earlier one was not rejected. Subsequently again fight. My case is my lord withdrawn thereafter fight. But the pleading prayer ground also quite important. And so far, my lord, this SMS pharmaceutical case is concerned, they are saying if already adjudicated, then cannot entertain second application, otherwise you can come out to own one. I'm not speaking to reduce earlier withdrawal on one line. And here, my lord, the principle of res judicata is not.
So if I may, my lord, Shamlal Verma, my lord, has come to this finding, my lord, after going through Anil Khandikwala and SMS Thomas. As an authority on this point, after going through all the previous.
Change circumstance means materially different. Some document already been laid up. Materially different. So Anil Khandeola case. Change circumstances or materially different from earlier. Materially definitely different. So
But the in which case we don't have flavor. In particular, it's EQ1.
Ah.
Yeah.
And SMS certificate
SMS also withdrawn with
withdrawn. No.
SMS not.
Withdrawn. SMS commercial.
SMS commercial, my lord, paragraph
28.
32 saying, my lord, if it already been earlier one was quashed, refused to quash, then subsequent application not. No, my lord, SMS.
SMS paragraph 28.
Paragraph, my lord, 32 saying that earlier one rejected on 12/12/1968, then subsequently that order cannot be reconsidered in review. And ultimately, my lord, review court saying that has no 32. Maybe. We may, however, notice that this court in Superintendent and DM of Legal Affairs, so Hunting, held that when there is a change set of circumstances, the second application under Section 561A of the Court of Criminal Procedure would be maintainable. That is, para 20, para 2. The main question debated before us was whether the High Court has jurisdiction to make the order, that is 7/4/1970, quashing the proceeding against restaurant number 1, 2, and 3, when on an earlier application made by the first respondent, the High Court had, by its order dated 12/12/1968, refused to quash the. Mr. Secretary, on behalf of the state, contended that the High Court was not competent to entertain the subsequent application of restaurant number 1 and 2 and make the order dated 7/4/1970, quashing the proceeding, because that would tantamount to review of it earlier. So my case is quite different. So one line withdrawal order, I am not seeking to review that order. That's gone. And here, my lord, the Khandeola case saying change circumstance or being materially different. And my case is materially different. Earlier, my lord, some document I also was aware, but this document was not available.
Anil Khandekwala,
Therefore,
statutory provision was not complied with. 32 certificate, he had resigned before the check was issued. Section 141 of the Negotiable Instruments Act makes a person liable who is in charge of a company during managing the affairs of the company when the check was issued. That is the reasoning of Anil Khandekwala.
Opposition of
He was not a part of the company when the checks were issued.
Opposition of law saying
that, as Lordship on the first occasion has pointed out, my lord, if there is a delay in filing, my lord, 138 delay, my lord, that is not curable, my lord.
Verma,
like that, my lord. Yes, sir. This is different. A different check, my lord. Yes. So, this is the yes, sir. But you are only using 29, not 81.
81. Otherwise, my lord, 321 segregate, my lord, and it will,
No,
it will hard.
Will be passing out your the other case where they already.
Otherwise,
in phone number Nimish Mahathir. The structure of the quota of party not really left account after 20 party
Email number
Obliged.
819. There is an interim. Hello.
Obliged.
Dr. Ram, on behalf of Mr. Ahmed, I am on behalf of Mr. Ahmed. Petitioner side is not here. Dr. Moments ago, Mr. Kalor is not here. I'm trying to contact him. Yes. Yes, Dr. After 6th of August, any day. He will be out of place.
Earlier, the
Assam police investigated.
draft the document
That-
was withdrawn.
Hmm.
But lawyers are not fit for a prayer. They have been- What they will call for a
Record. Will get stopped. Scan copy of the record should be kept.
that does
Hmm.
have the record.
The process is stopped for so many years. 12 or petitioner side is also not here. M. Bora. Please engage perhaps with the Gogoi and SR. I'll inform Mr. Bora or just to send back the record.
Please, your lordship. I'm waiting for the. Yes, sir. Don't have to account for the death was some person. I need to the for the. There are so many. My colleague that informed me the fact of this, but there are so many at least we at least we cannot function for the day only. Our day the take the wait. Lordship, please just return for the day, Lord. That I was just informed by my colleague that I had to take time. That's why I'm not prepared for it. Topic or by your colleague of the top that comes up have here. My colleague was here, Lordship. He just how many lawyers are there? What about Lordship, I'm how many lawyers are there? I'm very sorry. Because you were also thought. Lordship, can we explain for today? Because it Lordship, either you vacate the earlier order, just paid or paid 10,000, 5,000, repeating. Lordship, kindly. Lordship, not this matter is of 2,000. You have to decide. Let me fix it tomorrow. Not the page. Not 45 with the thought. Pay cost. The hypothetical sub. I think you can know the facts that take part. Kindly we know one day time. Even when you are not supposed to infect a clear, but not your name is not there in your color. Yes. The kind we do not know who authorized you. Kind. Sometimes you should not be kind. Just for a day, Lord. Because if your the court is kind enough, 2012 you aren't paid. We're in 2024 with the and kindly for today, Lord. Kindly for today, Lord. That's all. So next time my colleague will be there, Lord. None of the council they have continued to should not be name is not there. Kind of a bit for paper. Sorry. But the next time my colleague will be there, we don't know. Then not name is not you. Name is not your senior. But if we may not prepare somebody to record, to record this here. That's not the way for a senior to do. He has taken the responsibility. But if my we do not know, he should not have sent you to the court first of all. You are not yet put it on record. So why you have come? You write in the order. While dictating the order. What's your good name? I'm a South Secretary. Uh, uh, with the great nothing. That if when did you sign card? When you have joined 51 lot.
it shall be done. So this is your 38. Yes. But a humble period of cost may be short. But not support. Hello. I am for a restaurant 2 to 7. It was earlier filed under section 397 law. And subsequently, by the order dated 5/12/2012, so the same was converted into criminal case. Section 372. It is filed by the complainant, not the victim.
There's nothing to worry about. Your equity.
Yes.
But K position, right? Not K. Not weird. So it's a bit.
Shooting as well as the lesser punishment. In respect of the personal fee, 1,000 fine was. Hello.
Anyone of you are acquainted with your money data? Timothy, your money data is appearing in this matter. Our letter of December. Are you expected to your money check? Why just leave up deal or something? What will happen is will appear. You cannot astonish the up to December 2024, matter is 2030. Are you a junior to her? What's your good name?
Vijay.
Cannot astonish for such a long. There is another count. This junior wants the Sharma is this.
P. Sharma, dead.
Right. What is this?
Prime Minister, sir.
Oh. What's it? But it was filed by him, not by what is happening?
Immediate.
What is it?
Like your money there.